Ms. Nicholson?
Your Honor, it's my understanding the defendant will be entering a guilty plea to counts 1 and 3. Count 2, the OVI refusal will be dismissed, and we will ask the court to conduct a PSI.
All right. Okay. Well, that's my next question. Do you take medication that interferes with your ability to understand what we're doing?
No, I understand.
Okay.
I understand.
This is how you want to proceed?
Yes, sir.
Okay. Ms. Nicholson?
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about August 11th, 2025, in the city of Springboro, officers observed the defendant run a red light. Once behind his vehicle, they observed him drifting within his lane. A traffic stop was made. The defendant was observed to have bloodshot and glassy eyes. There was a strong odor of alcohol on his person. He was unsteady on his feet once he exited his truck, was swaying back and forth. He admitted to having 2 beers, but declined any further testing. He has a prior felony conviction for operating a vehicle under the influence out of Illinois in March of 2019. He also had a paper containing a white powder in his pocket that was found during the booking process, and that was determined to be 0.169 grams of cocaine, a Schedule II substance.
Mr. Borger, anything on those facts?
Your Honor, nothing on the facts.
All right. Mr. Overhill, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
I do, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights you and I went over.
Yes, Judge.
What is your plea?
I plead guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed, and the court will accept your plea of guilty. Based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Mr. Overhill, I'm going to order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time, okay?
Okay.
Ms. Nicholson, it'll probably be April.
Okay.
We'll just vacate the trial date. This is case number 25-CR-42946, the State of Ohio versus Craig Overhool. Mr. Overhool is before the court with his counsel, Mr. Borger. Ms. Nicholson, on behalf of the State of Ohio, we're here for sentencing. Ms. Nicholson, anything on behalf of the state?
Your Honor, Mr. Overhool has a number of prior, I know he did a lengthy prison sentence in Illinois for a felony OVI. I know he tested positive today. I know he's denying use. We do not believe the minimums are appropriate in this case, but would otherwise defer to the court. He has 31 days of jail time credit.
Thank you. Do you have, was he under an ALS?
Yes, he refused, so he should have, yes. So the date of offense was August 11th of 2025.
Thank you. Anything else from probation?
Nothing further, Your Honor.
Mr. Borger?
Your Honor, obviously my client has pled guilty. He is denying the cocaine use or the allegation of that. We understand what his history has been. This is not the most egregious OVI, but an OVI nonetheless is an OVI, and I totally understand what the prosecutor's position is on this. My client was employed at the time, has maintained some employment throughout, and I think something that should be factored into this is that during the pendency of this case, he did have a stroke. That stroke has had a debilitating effect on him, which has made him really unable to maintain employment. He's got vision issues. You can see he's got a tic. It's had an impact on his ability to speak. We are advocating, of course, for the minimums, but understand that it's the court's decision as to what that is going to look like.
All right. Mr. Overhool, anything you want to tell me?
My health is bad, but I can't really see. It's just hard for me to think today. I'm sorry for what I've done.
Sir, did you use cocaine?
No, I don't. And
the lab is going to tell me, and it could come back that it was a false positive, but I mean, it's better to come clean now.
Yeah.
With me, if I find out that you've lied to me.
I understand.
Okay. I just want to give you a chance to come clean with me right now.
I understand. Yeah, no, nothing. And I've been negative all the time. Yeah, I had the alcohol bracelets on, and that really broke me. But the last time I tested, we had to have another guy look at it because it showed positive. But then he said no, it was negative. But yeah, I would be honest. I've been honest throughout the hearing.
How many OVIs have you had in your lifetime?
Do you know?
I believe this is his 5th, Your Honor. It looks like 2 may have been out of the same, convicted on the same date, but different dates of offense. They're different case numbers out of Illinois. And then he had a 2008 out of Illinois, which appears to have been a felony. And then he had a 2018 felony out of Illinois, which stated 3 or more priors. And that's what he did a pretty lengthy prison sentence on.
All right. Anything else you want to tell me?
No, thank you.
All right. Court's considered the statements made here today the pre-sentence investigation of purposes and principles of sentencing, the relevant seriousness and recidivism factors. Mr. Overall, I know you served a pretty lengthy sentence. In fact, the sentence that you received in the Illinois case is longer than I even have the ability to sentence you to. But that being said, the court is going to find that you are not amenable to community control. In fact, prison is mandatory in this case for a minimum of 60 days, but I'm going to order you to serve 36 months in prison. You have credit for the 31 days you've already served. There's a $1,540 mandatory fine, which I do not have the authority to waive. The court finds that you're indigent for purpose of any other fines, costs, or financial sanctions. But the mandatory fine is required to be there. Suspending your driver's license for the remainder of your life, that to be effective as of August 11th, 2025. The ALS will be terminated. And you're also subject to a discretionary period of post-release control, which means upon your release from prison, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison by the adult parole authority for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost.
That 36-month sentence is on the OVI. Do you want any sentence?
Oh, I'm sorry,
imposed on-
12 months concurrent.
Okay, thank you.
All right, Mr. Overhill, there is the deputy standing behind you. At this time, you are remanded into the custody of the Warren County Sheriff for transport to the Department of Corrections.
Again,
You waived all other fines and costs.